I welcome you all to Clat lecture series. This is lecture number one in Law of Torts, sponsored by Shrijendra Rangson. I'm your mentor, Shekhar Gehlot. So today, in this lecture, we will begin with a new subject called Law of Torts. Okay, this may be appearing to you a new word. What is a tort? And I am really sure so many of you may not even have heard about something called torts. So, but I tell you that it is a very important branch of law, as important as we have our service laws, as a criminal law, as a civil law. It is just equally as important, okay, not less than that. It is a very important branch of law which came out as a common law. You give a quick reading to what is written here, and then we will discuss the law of tort in a minute or two. So now let us read about tort. Okay, tort is a civil wrong other than breach of contract, and it attracts penalty in form of compensation given to the injured party. The word tort is derived from tortium, a Latin term meaning to twist or crooked. It implies a conduct that is twisted or not straight. The law of torts is based on the principle ubi jus ibi remedium, which means that for all wrong there is a remedy. Okay, now let us declassify this tort. Okay, tort is a Latin term which means twisted or crooked. Okay, twisted or crooked. Any action which is twisted, which is not straight, twisted or crooked. Crooked means wrong. Tort is something, tort is an action which is twisted or crooked. Plus, not arising out of contract. It is not arising out of contract between the parties. Okay, why? Because when there is a breach of contract, when there is a twisted action within a contract, I have a contract with you and I commit a wrong act as per the contract, then what would we call it? We won't call it a tort, then it will squarely be classified as a breach of contract. Okay, it will squarely be classified as a breach of contract, but we are discussing tort, we are not discussing breach of contract. Breach of contract we have discussed enoughly in the law of contract series. It is law of tort. So tort is something, an action which is twisted or crooked, plus it does not arise out of a contract. First of all, there is no contract at all, okay, between the parties. If there is a contract, then it will become a breach of contract, it will not remain a tort. Third remedy is civil in nature. Remedy is civil in nature. That means there is no criminal penalty. When we talk about remedies, we have two type of remedies in the law. One is civil remedy, other is criminal remedy. Okay, what is the distinguishing feature between both these two remedies is when we talk about a criminal remedy, that means we are seeking a punishment for the wrongdoer, and punishment is in the nature of sending him behind the bars, putting him inside a jail. Like you have heard a lot of times, somebody committed a murder, somebody committed a rape or dacoity or robbery or theft or chain snatching or illegal possession of arms or narcotics and so on. Okay, these are criminal wrongs. And what is a criminal wrong? A criminal wrong is one which is classified by the law as a wrong activity. Okay.
It's
So
12
in the
o'clock.
criminal wrong, what do we seek? We seek the punishment. What is the kind of punishment in the criminal law? In the criminal law, punishment is sending someone behind the bars, behind the jail, depriving him of his liberty. But when we talk about remedy in civil nature, like we discussed in the law of contract, okay, law of contract, the breach of contract is a civil action. Then what would happen in a civil action? You do not seek jail term for someone. You seek money. You seek compensation in the nature of damages. Okay, so remedy is civil in nature. That means if someone commits a tort, the remedy is civil in nature. That means he will get some monetary compensation. Monetary compensation alone and no jail term etc for the offender. For the offender or tortfeasor. Usually the one who commits a tort, we call him a tortfeasor. Okay, tortfeasor. Okay, plus damages. What kind of damages are we seeking? What kind of damages in the tort we are seeking? Okay, damages are of two type. Okay, damages usually are of two types: liquidated and unliquidated. Liquidated damages are those damages which are predetermined. Okay, liquidated damages predetermined. So when can you predetermine a damage? You can definitely predetermine a damage when you have a contract with the other party, isn't it? When you have a contract with the other party, you know that what is going to be the transaction between you people, and how much loss can you suffer because of the actions of the other party. So you are very much aware of the kind of damages, how much monetary damage you can suffer. So you put it down in the contract that if one party breaches the contract, the other party shall pay 1 lakh rupees, 2 lakh rupees, crore or 2 crores, something like as a compensation, which is a predetermined compensation based upon the value of the contract. Okay, but because law of tort, there is no contract at all. I have a no contract with you not to commit a tort with you. Okay, when I commit a tort upon someone, do I have a contract with other person? We do not have a contract with other person. Okay, let us discuss a case of tort. Usually what happens if I'm driving my car in a very negligent manner and I hit a pedestrian and he has suffered a fracture, do I have a contract with that person that when I drive the car on the street you should not be on the streets, and if you are on the street I will hit you? Or do I have a contract that when I drive the car I do not hit you? There's no such contract between me and the pedestrian which I have hit. So we definitely cannot predetermine the damages. We do not even know how much damage is going to be caused to the other party. Whether if I hit someone, he will die, he may suffer a fracture, he may not suffer a fracture at all, he may have a simple injury, or he may not have an injury at all. So, how do we determine that tomorrow if I hit someone, how much compensation should I pay that party? It cannot be. It will always depend upon the circumstances, how much damage I have inflicted on the party, isn't it? So in this case, damages cannot be liquidated. Damages cannot be liquidated because you cannot predetermine. So we have another kind of damage that is called unliquidated damages, not predetermined. Okay, so law of tort deals with unprecedented situations, situations which are not arising out of contract, so you do not know when they will happen or not. So that is why we have damages in the law of tort which are only unliquidated. Okay, we have only unliquidated damages in the law of tort. This is the law of tort. Now you must be understanding that he is talking about tort. Tort is some action which is twisted and so on or crooked or this and that. But what is tort actually? What is actually a tort? What am I trying to talk to you people here? You may be thinking. But we will proceed and you will have a better and fair understanding about the law of tort. Okay, let me give you an example here. I have a hotel. In the hotel, I have provided a swimming pool, but pool does not have much depth. Pool does not have much depth. Pool is not deep enough. Okay, but I have not placed any sign about shallowness of pool, of swimming pool, of pool, nor there is any life coach nearby to instruct people. Okay, so this is now my hotel. I have a swimming pool. Pool is shallow in nature. Pool is not much deep. Okay, you can just expect the pool is about chest heighted. Okay, the water would come to my chest of a standard person, 5'10" height, to his chest. Suppose 4 feet is the height of the pool, and the standard height which is required for the divers to dive into the pool is somehow 7 feet. So now what happens? A guest of my hotel. Okay, now a guest comes. He just wants to take a swim in the pool. So what he does, he takes a dive in the pool. Because the pool is shallow, he hits his head in the bottom of the pool and he suffers a grave injury. Now, who is liable here? Can I just call the guest liable because you saw the swimming pool and started diving? Is he liable to inquire hotel staff that whether I can dive or not? Yes, we may say he is liable, but because I have opened up the pool, it is first of all my liability to keep my staff posted there or to keep signboards there so as to say that no one is allowed to dive. Pool is shallow, please do not dive. If you dive at your own risk, and there's a lifeguard. And if after all these someone dives into the pool and suffers an injury, I'm not liable. But in this case, there are no signboards, no life coach, no warning, nothing else is there. And someone comes and takes a dive. Now he hits his head hard on the bottom of the pool. Now who is liable here? Definitely hotel is liable. Definitely hotel is liable. Okay. Hotel is liable. Now, does this guest have any contract? Does this guest have any contract regarding shallowness of pool with the hotel? Usually, no. Nobody has. People just book the hotel. Okay, and there are no such warnings at all at the booking time. So now there is no contract between the parties. And now what will happen to this person? Where will he put his case? This is not a criminal act as well. Hotel has not committed some crime, but definitely hotel has done something which is wrong. Hotel has done something. We don't have any act right now which says hotels have to do this and that. So there is no crime because crime has to be put into the law. So there is no law. But now someone has suffered an injury. Okay, he had a legal right not to suffer an injury or legal right to be informed before he takes a dive. But hotel has not fulfilled this right, this obligation. So now what will happen? Where would he go? He will definitely go in the law of tort. Okay, cast would go in law of tort and claim compensation. Okay, what compensation will he claim? It will definitely depend upon the injury. You cannot predetermine it. Can you predetermine that if you dive, how much injury will you suffer and how much price would be sufficient for you? No, it depends upon person to person. Person may be a billionaire or person may be poor person. A poor person will be quantified in a different manner, and a very highly rich person maybe will be quantified in a different manner. Suppose he's a footballer and he's now paralyzed, his whole career is gone, he will be quantified in a different manner. So we have different yardsticks for different people. So definitely we cannot predetermine the damages. That is why the compensation is going to be unliquidated in nature. That is to say, case to case basis, isn't it? That is to say, case to case basis, we will determine the compensation. So this is the law of tort, where there is no law and still something wrong is committed. And now, what will happen to that person? Where will this person go? Who has suffered wrong? Then he will go in the law of tort and he will claim compensation. This is the law of tort. Now you must be understanding. Or let us take another example. I travel by train. I travel by train. Train is liable to maintain the rail lines. Okay, isn't it? Now, train somehow does not maintain the rail lines, or maybe they maintain it, but somehow some accident occurred. Train derails, and I suffer a loss. I lost my luggage. I had something there which I had. I was traveling with a, it was a fair train. Sorry, not fair train. It was a what do we call it? It was a free train. Sorry, it was a free train. It was carrying my 20 cars, which I had purchased. Now 20 cars are damaged. I was also along with the car. I have suffered some injury. Now who is responsible? Definitely train is responsible. Now have the train committed a crime? No, train has not committed a crime. It's a pure accident. It is an accident. Train has not committed a crime. It's an accident. But train is duty bound to prevent accidents. But train could not prevent the accident. Train management. Now who is liable? I have suffered the loss. Who is liable? Train management is liable here. So what train management will do? Can I ask the train manager or train driver to be put behind the bars? No. Definitely they cannot be. They are not committed a crime. It's an accident. But I can definitely seek compensation. How will I seek compensation? I'll seek compensation in the law of torts. Torts law will provide compensation to me, and compensation will depend upon case to case basis how much damage I have suffered. It shall be upon that basis alone. Okay, so it can never be predetermined. So let's again come back to what is tort. Tort is something, some action which is twisted or crooked, which is not straight, which is wrong, not arising out of contract, because if it's arising out of contract it will be called a breach of contract. You people do not have a contract with each other. Remedy is civil in nature. You are seeking only monetary compensation. You are not seeking jail term. You are not seeking detachment of someone's liberty, that someone be put behind the bars, his liberty be taken. No, that can't be done. That can only be done in the criminal law. And damages are unliquidated in nature. Damages are unliquidated in nature. Okay, this is the crux of law of tort. Now we will discuss in brief, sorry, not in brief, in detail, what is the law of torts. And it is a very high scoring subject. It is often asked for 20-30 marks in the law of tort. In the Clat series, it is the most highly asked subject in the Clat other than Constitution of India. Now, the law of tort is based upon the principle ubi jus ibi remedium. We did this when we did the class of legal maximum legal torts. Okay, we discussed this. Ubi jus ibi remedium. That means where there is a right, there is a remedy. Or you can say for every wrong there is a remedy. If I have a right and someone violates my right, I should have a remedy for redressal of that wrong. Isn't it? If my right is violated, I should have a remedy to seek the grievance redressal at the court. Or you can say, for every wrong, there is a remedy. If someone has committed a wrong, there should be a way to set this person right, or to set that wrong action right. Isn't it? That is the law of tort. Now you read the purpose of the tort law after in this backdrop, and then we will discuss it meanwhile. Now let us read the purpose of tort law. What is the purpose this tort law seeks to achieve? Every law has a purpose. Like law of contract has a purpose to achieve a harmonious trade and commerce transaction within the country, so that people honor their obligations. We have a purpose of criminal law so as to avoid happening of the crimes. And if the crime has happened, you have to adequately punish the crime. You have to deter people from committing the crimes. You have to threaten people that don't commit a crime. If you commit a crime, we'll punish you. Okay, Narcotics Control Act has a purpose. It has a purpose of preventing people from using narcotics controlled substances which are not good for you. Okay, similarly, a purpose of tort law is there. What is the purpose of tort law? Let us read. To provide a peaceful means of adjusting the rights of parties who might otherwise take the law in their own hands. To provide a peaceful means. Now, see, let's take the example of the hotel. Okay, I have suffered an injury. Now, if there is no law, what would happen? Definitely, my family will go to the hotel. They will create a ruckus there. There will be a fight between the hotel staff and my family. A lot of people are going to be injured. A lot of property is going to be damaged. Someone may even die. People will take the law in their own hands if there is no redressal, isn't it? So the law says you do one thing. If something wrong has happened to you, don't worry. You don't panic. Don't rush to settle the justice at your own end. You come to me. I'll give you the justice. The court says you come to me. We'll listen to you. So to provide a peaceful means for adjusting rights of the parties who might otherwise take the law in their hand, we have a law of tort. Okay, to deter wrongful action. Okay, deter means threat, discourage people, discourage someone by threat. So law is giving a threat here to everyone that no one should indulge into an unfair or a wrong action, otherwise I'll take a legal remedy against you. I'll take the law will come into picture against you. So law is now deterring everyone. Law is now what law is doing? Law is discouraging people by providing threats that you should not do this. Okay, otherwise you will be punished and you will have to pay the compensation. We'll make you pay. Okay, so we are deterring people from doing wrongful action. Suppose if there is no law of tort, anyone will do whatever he wishes to, and then he'll say, "Why should I pay? It is happened. Whatever has happened has happened. Let's forget it. I will not pay," and people will be on the streets. There will be complete anarchy. Okay, so to deter wrongful action, we have a law of tort. To encourage socially responsible behavior, definitely it encourages socially responsible behavior as well. When people are aware that something wrong is committed, you will have to pay the fine. People will be more responsible. Like take the example of the COVID times, there is a fine on not wearing of the mask in publicly. So you see nowadays a lot of people, almost every 90% people are wearing their mask and nobody is spitting in the public. But if there is such no law there, if the law does not say that there is penalty on not wearing a mask, probably 50% people will behave responsibly and other 50% people will not wear a mask at all. They will say that what is coronavirus, it is all a hoax. Okay, there is no coronavirus at all, and if whatever has to happen, it is all willed by the god. This is also a problem with the India, no, not India, with everyone. They feel that whatever is destined to happen will happen. If I am supposed to get corona, I will get corona. Mask cannot save me. No, this is not the way. The law says you may get the corona. We are not worried about that, but you have to wear a mask. You should not be a carrier of the corona. You should not transmit the corona to other people, to encourage socially responsible behavior. Further, to restore injured parties to their original condition, insofar as the law can do this, by compensating for them injury. To restore injured parties to their original condition, insofar as the law can do this. Insofar as the law can do this, someone has suffered an injury, definitely law cannot put him back into the original position, but yes, monetarily law can compensate them for their injury. If I as a guest have taken a hit into the pool, okay, and my head burst happened and my head is cracked open, now I am on the ventilator, or on the I'm paralyzed for 6 months. Those 6 months of the quality law definitely cannot give me back, but definitely law can compensate me, okay, for the injury I have suffered, plus for the legal damages, plus for the medical damages, okay. So law, insofar as possible, okay, as much as possible, law of tort will try to put me back in the original position, as if I had not suffered any damage, okay, in the position I would have been originally. Okay. So this is the law of tort and the purpose of tort law, and how important this law of tort you can now understand from the bare reading of this particular slide which we have just discussed. Now we'll proceed ahead to the essentials of a tort law. You meanwhile give it a quick reading and we'll discuss. We'll come back to this in a minute. Essentials of a tort law. Every law has its own essential, like we discussed. Law of contract, it had its own essentials. Okay, constitution has its own essentials. Okay, that you have to follow certain conditions in order to be citizen of India. Okay, so everything has its own essentials. These are also called sine qua nons, like we discussed in the law of maxims. Okay, legal maxims class. Sine qua non is something which is essential for something to happen. Okay, so what is the essential of a tort? For an action of tort, there must be an act or an omission on the part of alleged wrongdoer. There must be an act. Act is here is a positive act or omission. What is omission? Omission means failure to do something. Failure to do something which was required, that is a negative act. Either you have committed a positive act, either you have willfully done an act in order to cause harm to someone, or you have by omission, or you have failure to take care of something, and ultimately without your intention something have happened, that is a negative act. So law of tort, for an action of tort there must be either an act or an omission on the part of the alleged wrongdoer, the one who has committed the tort. Wrongdoer is the tortfeasor. A person must have done some act which he was not supposed to do. Okay, someone has done an act which he is not supposed to do. The act or omission should result in a legal damage. Now that is very important. What type of damage we are discussing here? We are discussing a legal damage. Only legal damage is required for an action of tort. Any other damage is not actionable. Any other damage is not actionable. Now what I mean by legal damage, okay, we'll understand when we'll proceed ahead, but meanwhile you just keep it in the mind. Only legal damage, legal injury, or may say legal injury. Legal injury is the subject of the tort law. Only legal injury is the subject of the tort law, otherwise not. Hereinafter referred as damage, which means that the act or omission should result in violation of legal rights of the plaintiff of the complainant. Okay, plaintiff, or either you call it a plaintiff or you call it a plaintiff or the complainant. Now there are two important maxims in tort law. Okay, two important maxims which we have discussed in brief in the which we discussed in brief in when we were discussing legal maxims. Okay, now you read this maxim called injuria sine tamnum, and then we will discuss it in detail, and I'll explain to you what legal injury we are talking about in the law of tort. Injuria sine damnum. Okay, this maxim means legal injury without damage. Now you may be worried. How can there be a injury without a damage? There is no damage, but still you have suffered an injury. This is the crux. No damage at all, or say zero damage. 100% injury. What is this? How is this possible? Okay, this maxim, let's read it. This maxim means legal injury without damage. According to this maxim, whenever there is a violation of a legal right, whenever there is a violation of legal right, now we are talking violation of a legal right, not violation of any other right. Okay, we are not talking about a moral right. Okay, moral right may be anything, but we are talking concerned only about the legal right. Whenever there is a violation of legal right, violation means there has to be a intrusion into a legal right. The person in whom the right is vested, the person whose rights have been violated, okay, is entitled to bring an action, though is entitled to bring an action, though he has not suffered any damage. He has not suffered any damage, like no damage at all, zero damage, 100% injury. How? And may recover damages. He can recover damage without suffering damages. Okay, this is the law of tort. This is the beauty of the law of the tort, and I'll simplify it. Let us read further. It is sufficient to show violation of legal right, and the law will presume damage. Okay, violation of legal right gives right to legal action. It is sufficient to show that your legal right has been violated, and law will presume that damage has happened to you, even though damage has not happened at all. If your legal right has been violated, okay, if your legal right has been violated, then you are supposed to receive compensation whether or not you suffered some damage or not. Let us read the famous case Ashby versus White, from where this injuria sine dimnum, this maxim originated. Okay, What happened in this case? The defendant means someone who has committed tort. A returning officer at the voting booth wrongfully refused to register a duly tendered vote of the plaintiff. Now, plaintiff is HP, White is the defendant. What HP said, I want to cast vote in favor of my candidate. Suppose I want to cast vote in favor of Narendra Modi. Okay, and the returning officer wrongfully refused to let me cast my vote. He said, "I won't allow you to allow you to cast your vote." Okay, even though the person for whom the plaintiff wanted to vote won the election. Now I wanted to vote for the Narendra Modi, and he refused me to cast my vote. But Narendra Modi has ultimately won. So my purpose of the casting vote was to secure the victory for the Narendra Modi. Narendra Modi has won. Now I have suffered no damage, zero damage at all. Okay, but is there an injury? Yes, there is injury. What is the injury there? The injury is that I was not allowed to cast my vote. I was not allowed to exercise my legal right. There's a violation of my legal right that becomes my injury. So I have now suffered an injury. The court held that there was an injury to the legal right of the plaintiff and he was entitled to compensation. Now this maxim is explained very beautifully in this case. Zero damage, 100% injury. Okay, that is the law of tort. This is the essential of the law of tort. Okay. In another interesting case, Mercetti versus Williams, a banker, though having sufficient funds in his hands belonging to the customer, dishonored the check of the plaintiff. The plaintiff did not suffer any damage, but the court held that there was a violation of legal right of the plaintiff, and so the banker is liable. Okay, I have sufficient funds in my bank account. Okay, and now I want to withdraw my money. I go to the banker, I present him a self-drawn check that please allow me to withdraw 1 lakh rupees from my account. My account is having 10 lakh rupees. Banker says, no, I will not honor your commitment. I will not honor your this check. Okay, though I may not have suffered any legal damage. Okay, because I required that 1 lakh rupees for casual purpose only. There was no some serious business going on. So legally, really I have not suffered much damage, but there is a injury to my legal right. What is my legal right? My legal right is that no one should that banker should honor my check. This is an obligation upon the bank, isn't it? Bank is supposed to honor the checks. This is the principal function of the bank. No other financial institution can claim to honor the checks, only a bank in the world. And now bank is unlawfully refusing to honor my check despite my bank having sufficient liquidated funds. Now in this case, though I have not suffered much damage, let us say I have suffered some damage, I wanted some money, I can say that we have suffered, like, let's take it 20% damage, but I have suffered 100% injury. Okay, damage may be 20%, but I have suffered 100% injury, or it may be zero damage, 100 injury. Now here the law says that because you have violated somebody's legal right, now you are entitled, now you are liable to compensate him, even though the other party has not suffered a damage at all. This is the law of tort. This is the sine qua non of the law of the tort. These examples clearly explain the meaning of the maxim. Though there may not be any damage, but there is an injury to the legal right of the person, he is entitled to bring an action. Now there is another maxim which is involved in the law of tort. This is damnum sine injuria. You read it and I'll come back to it. So the other maxim is damnum sine injuria. Sine means no. Injuria means injury. Damnum means damage. Damage, but no injury. Okay, now this case is, it is inverse of the earlier one. It is 100% damage, zero injury. Okay, it is 100% damage but zero injury. What is it? Let us read it. The maxim means that there is actual damage without any violation of legal right. Damage has happened actually, but there is no violation of legal right. In such cases, there is an actual and substantial loss without the infringement of legal right. Substantial loss is being suffered by someone, but there is no violation of legal right. Okay, let us take an example how it can happen. A runs a school in his locality. Okay, suppose I run a school in my locality. It's called Saint GCS school. Okay, I have a Saint GCS school. I charge 100 rupees per student. Okay, I have good teachers for them, a nice playground and a computer room. Okay, now I am charging 100 rupees per student. Okay, suppose I am having monopoly in that area. Now, due to this, I am earning a revenue. I am earning 1 crore rupees per year, and now my lifestyle is as per my earning. I have taken some loans as well. I have to repay the EMIs as well. My children are studying in the heavy, expensive schools. My wife is accustomed to expensive things, luxury life. Now, what happens? Suddenly, a competitor school opens up very near to my school. Okay, the school is called XYZ school. The school opened up by the competitor is called XYZ school. The fees is 50 rupees per student. He has kept the fees, half the fees I am being charged. He has better teachers, a bigger playground, a well, and they have Apple products in the computer room. As well, they have, sorry, it is as well they have Apple products in the computer room. Now that means he is charging less and giving high facilities to me. Now what will happen? My students will migrate to his school. Okay, now my students have 30%. Students have migrated to his school, and 50% of the new admissions are down. So I have now suffered around 50% loss. Now I am earning only 50 lakh per year, but my expenses are accustomed to 1 crore per year. Now I am falling 50 lakhs short of my expenses. I am near bankrupt. I have suffered a substantial loss. A great damage is there. But has he committed something wrong? Has he committed some illegality? Is competition wrong? Is setting up a school near my school is a criminal activity? No, he has not done something wrong. This is a pure market. That's it. So he has not committed any wrong. There is no legal violation of my right. There may be a damage. I have suffered 100% damage but zero injury. Injury, when we say, we are not talking about loss in terms of money, but loss in terms of your valuable rights. Rights are valuable. Okay, for the law, only thing which is valuable is the right. So violation of right is the injury. Violation of your substantial loss is no injury at all. So 100% damage and 0% injury. This is the case. A suffers damage, economic loss, but his legal rights are not infringed, and A has no cause of action to take this case to the court of law. Now I have no case against this person. I cannot take this person in the court and say that, see, he has opened a school nearby me, due to which my revenues have fallen by half and I am having a struggled life. Court will say he is not responsible to see that you are having a luxurious life. It is your responsibility, isn't it? So this is how law of tort work. What are the sine qua nons of the law of tort? Now, what are the essentials of the law of tort? That there should be injury, there may not be damage. Okay, legal violation of right has to be there, damage may or may not be there. But if damage is there, injury is not there, or the violation of legal rights is not there, no tort is made out. So what is the essential of the tort? Essential of the tort is injury as in damnum. Injury has to be there, damage may or may not be there. Okay, now we go to the next topic and we'll discuss with general defenses of the tort. Suppose someone has committed a tort. Okay, I have committed a tort. I have hit someone with my truck and he was on the road. Now, what are the defenses which we may have against each other? Okay, suppose someone files a case of tort against me. What defense can I take? There are a lot of defenses which this law allows us to take. But let us read the first defense, which is voluntary non-fit injury. It was discussed in the VNFI, it was discussed in the legal maxims class as well. But now have a deeper understanding of it. You give it a quick look and then we will recapture it. Voluntary non-fit injury. This defense means voluntary taking of risk. Voluntary means voluntary. Non-fit means not fit for calling injury. One who voluntarily assumes risk is not fit to call out injury later on. Okay. Voluntary non-fit injuria is a common law doctrine which states that if someone willingly places themselves in a position where harm might result, when someone willingly places himself in a position where harm might result, where he may have some injury, knowing that some degree of harm might result, they are not able to bring a claim against the other party in tort or delict. Okay, in totally. Now, if someone would say why anyone would put himself in a position where some harm may occur, yes, there are situations in which people deliberately put themselves in situations where they may there may be some harm to them. Now, what are these situations? Let us read again ahead. Voluntary only applies to the risk which is reasonable. First of all, the risk has to be reasonable. Okay, which is a reasonable person would consider them as having assumed by their actions. Okay, that means a reasonable risk we are talking about. Okay, it's not that unreasonable risk has happened to you. Thus, a boxer consents to being hit and do the injuries that might be expected from being hit. Now we see a lot of MMA fights on the day on the TV. MMA fights, mixed martial arts, where people are just on the verge of killing each other. They beat each other black and blue. Can anyone file a case? No. Can anyone beat me black and blue on the street? No, he cannot. But if I am in a ring as an MMA fighter, as a boxer, definitely I consent to being hit. So I cannot later on claim that this person has beaten me very badly in front of public. Now he should compensate me, and there's a law of tort. My legal injury has happened. No, voluntary non-fit injury is a perfect defense for such kind of action. But does not consent to, for example, his opponent striking him with an iron bar. Okay, that means he has consented only for a legal fight, that you can hit me with the punches, but can you hit me with an iron bar? No, you cannot. Or punching him outside the usual terms of boxing. Okay, boxing has some rules and regulation. If you hit me outside those rules and regulation, definitely I have a cause. But otherwise, if whatever is happening within the rules, then he is protected. The other person who has beaten me black and blue is protected by the maximum of Valencia non-fit injury or voluntary non-fit injury, VNFI, whatever you call it, voluntary assumption of risk. Okay, therefore, if spectator watching a cricket match is hit by a ball, he will not be able to claim damages as he had consented to damage. Or if you have seen F1 races where cars are being driven at 300 km per hour speed, sometimes there are crashes, cars crashes, people die, and cars sometimes enter into the public's chairs as well, and people are also damaged, people suffer injury. then they are not liable to claim any action at all. But there is an exception to this thing as well. Okay. Now, voluntary non-fit injury does not apply to the cases of rescue. Okay, it does not apply to the cases of rescue. What is a case of rescue? When you are trying to retrieve someone from some danger. Okay, when you are trying to help someone out. Suppose there's a fire in a house, okay, and I'm trying to, there are two people locked in the house, there's one pet as well, two kids are there. So I, as a firefighter, will enter into that house in order to preserve or in order to save these people from catching fire or getting burned. Now, if I suffer some injury, that is a case of rescue. Okay, now it's a case of rescue. Why voluntary non-fit injury is not applicable to a case of rescue? We will do it with the help of an example. Suppose there's a person A. A puts a matchstick. Okay, or say A lights a cigarette near a petrol pump. Okay, near a petrol pump or at a petrol pump, due to which a fire is there. Okay, because highly inflammable petrol is a highly inflammable spirit, and due to which there is a fire in the petrol pump area. Now a lot of people are stuck there. Now one person or two persons standing nearby, they rush, they immediately rush to rescue the people. Okay, they immediately rush to rescue the people, and in order to save those people, they also suffer some, like say second degree burns, or they are burnt till the 20% burns they suffer on the face, on the hand, on the chest, and this and that. Now these two people who were standing outside, who jumped in to rescue people, now they brought a case of law of tort against this person who lit a cigarette at the petrol pump. Now this person says that you people yourself came to the risk. I lit a petrol pump, cigarette at the petrol pump, due to which it caught fire. There were four people at that time. I am responsible to those four people only. You are other two people who came in order to help people. Now you have assumed the risk yourself. You have yourself taken the risk. Now when you have yourself assumed the risk, you have come to rescue. Now why should I compensate you? Now in these cases, this is a case of rescue. It is a duty of every citizen or every person or a government employee to rescue someone if they can. So when I enter to rescue someone because someone's mistake, then the person cannot claim voluntary non-fit injury, a defense of voluntary non-fit injury, that these person themselves entered the petrol pump who asked them to do so. No, it is my duty. Okay, so in this case, I can claim action against this person, though I myself jumped into the fire, but still I can claim violation of my legal right against this person. Now, what is the case of rescue? He was acting in the rescue persons or property endangered by the defendant's negligence. Now, petrol pump is endangered by the negligence of whom? It is endangered by the negligence of someone who has lit a cigarette at the petrol pump. He was acting under a compelling legal, social, or moral duty. I have a legal, suppose I am a soldier, I have a legal duty. I am a firefighter, I have a legal duty. If I am a bystander, I have a social and moral duty there. Okay. If I am not a firefighter, but I am just merely a bystander, I have a social or moral duty. Or his conduct in all circumstances was reasonable and a natural consequence of the defendant's negligence. Or his conduct was such that would be a natural consequence. Okay. Suppose I see a car which is about to hit a child, definitely I'll run to save the child. And in that case, if I am being hit, he cannot say that he himself jumped in front of my car. No, I did not jump in front of your car. You were driving negligently, and due to which a child's life was at stake, and I have to save that child, and it's a natural reaction. Then it becomes a case of rescue, and now this person cannot claim the defense of volunteer non-fit injury against me when I file a case of tort against him in the competent court of law. Next sort of defense is plaintiff being the wrongdoer? You give it a quick look, and then I'll catch up with you within a minute or two. Now let us take the case second defense which is available to someone who has committed a tort. Suppose I have committed a tort against someone. What defense I can take other than valencia non fit injuria? The other one is plaintiff being the wrongdoer. Plaintiff means someone who is claiming that something wrong has occurred to him. Something wrong has occurred to him. The essential part of this defense is that the plaintiff did something which caused him the injury. Since the plaintiff did something wrong, he cannot claim any damages from the defendant for the injury caused to him. For this instance, if someone who tries to illegally enter the house of a defendant and is bitten by the dog, the defendant will not be able to claim damages from the defendant. Now you understand. See, he is not allowed to enter into my house. He illegally entered into my house. I have placed a board in front of my house that beware of the dogs. I have a ferocious dog in my house, meant only with the purpose to watch my premises. And if you enter my premises illegally, the dog is going to bite you. Now the dog has bitten you, and you are left black and blue. Now in this case, you cannot claim a compensation from me because this is your own fault. Further, suppose I am going on a street. Okay, I am going on a street I am going on a street. Okay, I am driving on a street, and suddenly there is a zebra crossing. You understand the concept of zebra crossing? There is a zebra crossing, and someone suddenly comes out of nowhere. Okay, and he is not following the legal rules. He comes out from the street anywhere running, just trying to cross the street illegally, and now he is being hit by me. Okay, now see, I am driving my car within the legal permissible speed limits. Okay, so when I drive my car within the permissible speed limits, and I am having valid license and everything is valid there, but this jaywalker, he suddenly enters the road and is hit by my car. Definitely now he is the wrongdoer. He cannot claim that I have caused an injury to this person, and he cannot claim anything from me because he is himself at fault there. Okay, this is the plaintiff being the wrongdoer. Now let us go to the another kind of exception or a defense which is available in the law of tort scenario. That is called inevitable accident. Okay, inevitable accident doctrine is a principle of tort of law that says that inevitable. First of all, you understand what is the literal meaning of the word inevitable. Inevitable means something which cannot be stopped, which is bound to happen. You cannot do anything to it. Even after taking all the precautions, something is supposed to happen, then it has happened. You are not responsible for something which is out of your control. Okay, inevitable accident doctrine is a principle of tort law that says that a person cannot be liable for an accident that was not foreseeable. Foreseeable means which he cannot reasonably expect to happen. Okay, suppose I am driving in the influence of liquor. I have consumed a lot of liquor and I am driving. I can foreseeably expect that I may commit some accident because I am not fit to drive right now. But this accident was not foreseeable. A person was taking all the legal precautions, and then also some accident happened that could not have been prevented by the exercise of reasonable care. Even after reasonable care, accident could not be prevented. It was so inevitable in nature. Highest degree of caution is not required. Okay, so now let us understand what degree of caution is required. It is not the highest degree of caution, it's a reasonable degree of caution which is required in order to call an accident an inevitable accident. Only reasonable, what a reasonable man would do in such a circumstance. It is enough that it is reasonable under the circumstances. However, the courts rarely use this doctrine at present and rely instead on the basic concepts of duty, negligence, and proximate cause. According to the authorities, once the plaintiff establishes a prima facie case of negligence, the onus means the burden of proof will shift to the defendant to prove inevitable accident. In so doing, the defendant is required to show how the accident took place and that the loss of control of the vehicle could not have been avoided at the exercise of greatest care and skill. Okay, now let us assume I'll give you a perfect example of what could be a inevitable accident. Suppose I am riding on a bike. Okay, I am riding on the bike. I am having all the valid licenses. I am driving within my speed limit as well. I am not under the intoxication as well. So suddenly what happened? The road is very plain, but road is not very well maintained. Suddenly there's a big pothole. Okay, and then there's a big pothole due to which my bike falls down, and and suddenly the car which is coming behind me, it applies emergency brake. When it applies emergency brake, the car behind that car hits the car. So now there is an accident. Okay, now there is an accident. Now the person files a case against the one who has applied emergency brakes. Now he says that a person on the bike fall in front of me. If I did not apply emergency brakes, my car would have ran over him, he would have died. It was my duty, he was suddenly fell down. I applied emergency brakes. That is why emergency brakes are provided in the car. And when I provided emergency applied emergency brakes, accident was caused with the car which was coming behind me, and the people suffered injury. Now this is a case of inevitable accident and I cannot be found fault with, so I am not liable for the tort. Okay, so this is a kind of inevitable accident we are talking here. The other act is act of God. The other act is act of God. The other act is act of God. Act of God, or we may call it vis major even. Okay, vis major means force major. Vis means force. Major means major force. Okay, which we cannot control. Reasonably, we cannot control at all. Okay, this is such a high level of force. Okay, that is called an act of God. Suppose an earthquake is there. What can you do? Okay, suppose there is a flood. What can one do? There is a heavy downpour. Okay, no one has seen these unprecedented rains. Or there's a hailstorm. A big size hail comes and hits you in the car, and now you apply sudden brakes and somebody else is hit. Okay, there's a hailstorm, there's an avalanche. What can you do in such natural calamities? Nowadays, our country is facing a COVID-19 pandemic. That is an act of God. What can the health service providers do in this scenario? Okay, these are acts of God. If something has happened by the act of God, no one is liable for this other than the God, and definitely we cannot prosecute the God. We cannot file a case against an entity which does not exist. God exists only in the mind, not in the reality. Okay, so let us read it. Act of God means accident occurs because of an unforeseen natural event. Event has to be natural, not unnatural. Okay, event has to be natural. Then only it can be categorized as a act of God. Otherwise, definitely, if something unnatural has happened, someone is responsible for this. In law, then the essence of an act of God is not so much a phenomenon which is sometimes attributed to a positive intervention of the forces of nature, but a process of nature not due to the fact of a man. Okay, any process of nature which is not due to fact of a man, which is not within the control of a man, and it is this negative side which deserves emphasis. Okay, so this is an act of God. Now I have a institute. Okay, my institute, and there are, suppose say 200 students studying at this particular point of time, and suddenly there is an earthquake of a high magnitude at a Richter scale measuring 9.5, and all the buildings in the area have collapsed down. Even my building has collapsed down. Out of 200 students, suppose say 20 people died. Now, am I responsible for that? I am not responsible for that. I did not cause that earthquake. Neither do I have a power. Even if I wish to, I cannot cause an earthquake. That's a particularly natural event. So, in that case, someone, suppose these 20 students who have died and other 20, 40, 50 who have suffered injuries, their parents, their families file a case against me in the court of law. Am I responsible? No, I am not responsible. Provided my building had strong foundations for the earthquake. If my building had strong foundations for the earthquake, and even after taking all precautions, earthquake would have rattled my building. So that is the case which is called an act of God. The criterion is not whether or not the event could reasonably be anticipated, but whether or not human foresight and prudence could reasonably recognize the possibility of such event. For example, loss due to earthquake, storm, heavy rainfalls. Okay, so if I have a reasonable foresight, if I have put all the measures to prevent an earthquake from happening in my building, then also earthquake comes and my building is raised down and some suffers an injury, then I am not responsible. It is particularly an act of God. Now the other
It's one
defense is
o'clock.
defense number 5 is the private defense. You give it a quick look and we'll come back within 2 minutes. Now, the other sort of defense is private defense. Okay, other sort of defense here is private defense. The right of private defense entitles the plaintiff to go to any extent in order to protect his life or property. An important thing to note in this is that the force used in private defense should be reasonable and used as a defense, not as an offense. Okay, this is the critical word here. The force used in private defense should be reasonable and used as a defense, not as an offense. Okay, now suppose someone is charging at me with a lathi in his hand. Someone is trying to charge me with a wooden cane in his hand. Can I shoot this man down? Will that be reasonable for me to kill that person? Do I have an option to run away? I can run away. He can chase me. Definitely, he has a lathi in his hand. He can chase me. But what can I do? I can hit him with a stone. I can hit him with a brick. I can hit him with a lathi. But can I hit him with an iron rod in return? No, usually no. But depends upon the circumstance. If the person is really mad at me and he is about to kill at me, I can definitely shoot him there as well. But usually, it has to be very much reasonable. Someone is trying to beat me with his own hands, and then what I do? I pick up an iron rod and start beating him black and blue. And now I have caused multiple fractures in his body by using that iron rod. Can my force used in the private defense be called proportional force? No, not at all. Okay. Plus, it should not come as an offense. I should not be the offender. It is not the case that I started beating someone and then he started beating me back and I hit him with a rod by saying that I was trying to save myself. No, I am the offender here. Okay, I am the offender here. So, the right to private defense is a basic right, definitely. Okay, You have a right to defend yourself. If someone is trying to beat you down, if someone is trying to do unlawful activity with you, definitely you will protect yourself. You cannot wait for the law to come in its picture and help you out. No, you will have to take the whatever is the necessary precaution, whatever is the necessary reasonable measure to thwart that attempt or to thwart that attack on you. So in that case, law allows you to do some kind of private defense. If someone is hitting you, you can hit him back. But if you have an option to run away, then you have to run away. You cannot hit him back. It all depends upon the circumstances. Someone is running against you with a pistol in his hand, and you expect that he is going to kill you, and somehow you get a pistol and you kill him. Okay, you get a pistol and you kill him. Then definitely your right to self defense is there. No issues, nothing wrong will happen to you. Nobody can say anything to you. Law will be at your favor, but not if you are using unreasonable force. You are the offender yourself. Okay, like this. Also, the danger must be imminent. Danger must be imminent. That means it should be present at the moment. Present at the moment. Okay, there is no escape from there. It is not that someone telephones you or sends you a WhatsApp that I'll beat you tomorrow, and you do not even wait for tomorrow. You go today evening to his house and beat him black and blue. No, this is not a self defense. You cannot say that as I was afraid tomorrow he's going to beat me, so let's beat him today itself. No, this is not a self defense which the law is envisaging here. Imminent threat should be there, that within seconds if you do not do something, something wrong will happen to you. That is the imminent threat we are talking about. If you have half hour or 1 hour rest between the threat, then law expects you to go to the law enforcement authorities. Law expect you to go to the police and complain, or to hide out, or to do something, but not to cause harm. But if you are having an imminent threat, suddenly someone has come up and he is about to lash at you, and you are threatened dearly, then you definitely can take law in your own hands. Basically, it's not called taking law in your own hands, it's called the using of right to self defense. Okay, but your force has to be reasonable. What force you are using on that person has to be very reasonable. You cannot be highly unreasonable while using force on that person. For instance, a person warns a person that in the evening he will bring a gun and shoot the plaintiff. And the plaintiff waits for that person. And when in the evening he comes to attack the plaintiff will not have the right to private defense, because he had the time to inform police about the matter. Okay? Because he had the time to inform police about the matter. Now he cannot take this. Take another example. If someone punches you on stomach and you shoot him, that would be an excessive use of force, which is not necessary for defending yourself. Now you understand the crux of the right to private defense. You have a right to private defense, but it should be an imminent threat, plus your response should be proportional. Your response should be reasonable. You cannot be highly unreasonable. You cannot do whatever you wish to do. Okay. The following must be satisfied in order to claim this defense. What are the requirements for this defense to be satisfied? The defendant must be under threat or under attack. Okay, defendant must be under a threat or under some attack. The defense must be for self defense and not for revenge. Okay, the defense must be for self defense and not for revenge. Okay, it is not for revenge. The response must be proportional to the attack or threat. The principle for this is that the law will not hold you responsible for an action that you performed in order to save or protect yourself. If, however, it was not necessary to use force for protection, the law will not protect and you can't use this defense. Okay? If it is not reasonable, you cannot protect yourself. Law does not allow you that opportunity. Next difference to the tort is mistake. And the next one, further next one is necessity. Okay, I am adjusting the screen. You read the mistake and necessity, and then we will discuss about it within a minute or two. So, other is mistake. Now, what is a mistake? Mistake is not usually a defense in tort law. Okay, mistake is not usually a defense. Okay, it's not good enough to say that you were not aware that what you were doing was wrong. Okay, you definitely cannot say that I was when I was driving at a high speed, I was wrong. No, you cannot say so. It is not usually a defense, but there are two type of mistakes like we have discussed. Mistake of law or the ignorance of law is no excuse. Ignorantia juris non executed explains the same, that ignorance of law is of not defense. We have discussed this enoughly in earlier classes as well, in the case of law of tort as well as in the legal terms and maxims class as well. So you can refer to those classes, but still for your better understanding, I'll just give you an example. Suppose in Bihar, liquor is not permitted to have, but in UP you can have liquor. So you take liquor in UP and you go to the Bihar, and then you are caught there. You cannot say I was not aware that liquor consumption or possession of liquor is punishable in Bihar because it was valid in UP. I thought that same law exists in whole of the India. I never knew Bihar is following a different law. So this is not an excuse. You cannot say so. Okay. But mistake of fact is a defense but cannot be used in every case. Okay, mistake of fact, it depends on case to case basis, but you cannot use it in every way, every time. Okay, now just understand that suppose you are in a house. Okay, you are in your house, and suppose your friend has come. Okay, it's your birthday. In the night 12, your friend has come to surprise you, and he does not wish to tell you because it's a surprise. So, what he's trying to do is he's trying to scale your wall. He's trying to jump the wall of your house in order to surprise you and bring a cake for you. But you think that he is a thief in the night, and you pick a cane and start beating him. And then he tells that he's your friend. Then this is a mistake of fact because you genuinely presume that he is a thief, but it was a fact that he is not a thief, he is your friend. So in these cases, definitely you can have a defense of mistake as a defense of tort, but not in every case. Okay, usually it is very difficult to bring your case in the mistake of fact scenario. Okay, so it is a defense, but is a very weak kind of defense. In the tort law, the defense of necessity gives the state of an individual a privilege to take or to use the property of another. Okay, in tort law, the defense of necessity gives the state or an individual a privilege to take the use of property of another. When you have necessity, it was necessary to do so, you can take the defense. A defendant typically invokes the defense of necessity only against the intentional torts of trespass to goods, trespass to land, or conversion. You usually use this defense when you are committing tort of trespass, when you are when you are using somebody's goods, you are using somebody's land, etc., for your own use or for the public use. Then you can use the necessity as your defense. Okay, the Latin phrase from common law, necessitas inducit privilegium quod jura privata. Necessity induces a privilege because of a private right. A court will grant this privilege to a trespasser when the risk of harm to an individual or society is apparently and reasonably greater than the harm to the property. Okay. In necessity, one has to show that act done was necessary in the circumstances. Private necessity is the use of another's property. Okay. Private necessity is use of another's property for private reasons. Well established doctrines in the common law prevent a property owner from using force against an individual in a situation where the privilege of necessity would apply. Public necessity is use of private property by a public official for a public reason. The potential harm to society necessitates the destruction or use of private property for the greater good. The injured private individual does not always recover the damage caused by the necessity. It simply says that necessary act has to be done, and any private person or a public official, like when there's a construction of dam or a construction of highway, government will acquire a lot of land, government will relocate a lot of villages because it is necessary to construct a dam, and villages have to be relocated, otherwise they will be submerged, tomorrow people will die. Or when you have to construct a highway for the greater good, then you have to acquire someone's land. Or let us take an example, suppose there is a fire, okay, fire in one field, and it is a threat that fire will spread to other fields as well. So a person, what he does one thing, he goes up and lights the field belonging to Sham, so that till the time fire reaches to the Sham's field, the field is already burnt and fire does not spread. Okay. Now, Ram has no cause of action or Shyam has no cause of action against Ram in such a case. This is the thing of necessity. This is how you deal with the necessity, but you have to show that it was actually necessary in order to prevent a greater harm. You did some smaller harm. Okay, in order to save 100 lives, you took down one or two lives, or you, in order to prevent harm to 100 properties, you burnt down 10 other properties in order to save 90. So now in these cases, these are the cases of necessity. In such case, court cannot find fault with you, neither the one who has suffered injury can claim tort against you and say that you should compensate him because you were acting under necessity. This is when you are doing it in the private capacity, plus the government may also do so. Okay, government may also do so. Now government feels like that your institution which is dilapidated conditions, which is in very shaky condition, if some small earthquake even comes, your building will fall and a lot of people are living in your building, they will all die or they will get injured. So what government will do, government will create an order and say that all the occupants of the building should leave the building within 24 to 48 hours, and later after vacating the building the government can successfully bring down the structure, and government will not pay you any price for bringing down the structure which is unsafe. Okay, and you'll have to rebuild it at your own cost. This is the law of necessity which allows government to take action. Now what is the last defense available? Last defense available is statutory authority. If the act was done under authority of a statute, that is a valid defense. Okay. If whatever act has been done is done under the authority of law, that is a valid defense. For instance, if there is a railway line near your house and due to the noise of the trains passing by disturbs you, you have no remedy because railway line was constructed under the authority of a statute. Though there is a responsibility of the authorities to be responsible in respect of conducting the work, okay, but you are you cannot claim a tort because whatever is done is being done in the statutory authority. Okay, suppose now a judge sentences someone to be sent behind the bars for 10 years, or judge sentences that someone be hanged till death and someone is killed, someone, sorry, not killed, but someone is executed at the orders of the court. Now can the people go to the court and say that this judge has ordered the hanging of the person and the person has died, so he is responsible for killing our son or the family member? Can they say so? No, they cannot say so. Why? Because what judge is doing, he is doing under the authority of law. He has the authority of law to maintain law and order in the place. So when he does something in the authority of law, you cannot find fault with that particular person. Okay, you cannot find fault with that particular judge. This is the statutory authority, or when the government acquires your land. Okay, so this is a valid defense. Now we'll take a 5 minutes break and then we'll go to other chapter, that is capacity to sue or be sued. Meanwhile, you read it and then we will come back. So now we come to topic C in the law of tort. Okay, capacity to sue or be sued. Okay, who can file a case of tort or against whom a case of tort can be filed? You people may have read it. Meanwhile, we were on the break. So now it's the time to discuss. Let us discuss who can file a case or against whom a case of tort can be filed. Okay, first one is minor. In India, minor is a person who is below the age of 18. A minor can sue just like an adult. Okay, a minor is someone who is minor in India. First of all, you should understand we have an Indian Majority Act. Okay, we have an Indian Majority Act which says, okay, person above 18, 18 or above shall be considered major as per the Indian law. So anyone who is below 18 is a minor. This is not some rocket science. Everyone knows it. So let's proceed ahead. A minor can sue just like an adult. A minor can file a case against someone, a tort of law. Suppose a tort is committed against a minor. Suppose some legal injury is inflicted upon a minor. Yes, minors do have right. Okay, so a legal injury is inflicted upon a minor. Then what he can do? He can file a case. Definitely, he has the capacity, and he can file a case just like an adult only, just like an adult would do. The only difference is that he'll have to act through an adult. He'll have to act through an adult. Who this adult can be? Father, brother, mother, like all relatives or friends. And if minor is not able to find someone, if minor is not able to find someone, then what will minor do? Okay, minor will make an application to court, and court will appoint a major, an adult, to proceed with the case. Okay, now suppose there is no adult person available with a minor. Now how do we file a case? In that case, it is not that he cannot file a case because he is not able to find an adult. He can make an application to the court that find an adult for me who will represent me. Then court will find a proper adult person in whose name the case will be filed. He will act as a guardian of the minor. That is how a minor can file a case, and also a case can be filed against a minor. When a case will be filed against a minor, the case also will be filed against an adult only. Okay, through an adult only. Or if you do not know any adult for a minor, then you will apply to the court that I want to file a case against this minor, but I am not able to find any adult who can represent this minor. So the court will appoint an adult person, okay, for the minor to be represented in the court. This is how the law works. Corporations. How you can sue for a corporation, or how a corporation can sue you. The companies, corporations are usually the companies. Okay, companies, big companies, small companies, whatever companies. Okay, company can also be sued for the action of their employees, because we have a principal agent relationship between the employees and the corporation. Corporation is liable for the actions of its employees. Okay, so when a state transport bus hits you, you will file a case not against the driver, but you will file the case against the whole corporation, and you will make driver also a party, but the case will lie against the corporation. Okay, Tamil Nadu State Transport Corporation, whatever is the name of the corporation we have there. In Delhi, we have DTC, Delhi Transport Corporation. So if a bus hits me, okay, then I'll file a case against the DTC department as well as that driver, both of them. Okay. So companies can also be sued for the action of their employees committed when acting as employees of the company. But it is only when you are acting as an employee of the company. When you are acting as an employee of the company, we will see later on in detail. Companies are treated as persons in law for the certain purpose of law. Artificial persons like companies are also referred to as juristic persons. We have discussed that companies have their own separate legal existence, their own separate personality. Okay, their own separate personality company has. So company can act just like a legal person, but that legal person is artificial legal person, because this person is created only for the convenience of the court. Otherwise it has no natural occurrence at all, only a legal fiction it is called. Act of state, the government. Okay, when the government is acting as a state, cannot be sued for any claim arising while it is acting within its governmental or sovereign capacity. Otherwise state can be sued if it is acting outside sovereign functions. Okay, government cannot be sued when it is acting within its sovereign functions, but when it is not acting in its sovereign functions, you can sue it. Now let us understand what are sovereign functions and what are not sovereign functions. Okay, now there's a farm bill. Okay, in fact there are three. Let's take a farm bill. Farmers are agitated. Farmers say we will suffer a loss. Okay, and we had a legal right to not suffer that loss. But because we have brought a law, we are suffering a loss. So can they all file a case of tort against the government? The answer is no, because government is acting into the sovereign function. What is the sovereign function of the government? To legislate, to make laws, to make policies. Okay, these are the sovereign function of the laws. If some policy is brought by the government, like demonetization was brought by the government, a lot of people suffered losses and inconveniences due to the demonetization. But can they file a case of tort against the government? No, they cannot file a case of tort against the government, because government is acting it in its sovereign functions, and government is protected from the maxim which says king can do no wrong. Okay, the maxim originated in England. It said, now we do not have kings, so our kings are replaced by the governments. Now governments can do no wrong. Okay, or suppose a police officer, he arrests you. You have committed a crime, he arrests you. Then you cannot file a case against the police officer for making an arrest, for depriving you of your liberty, for depriving you of the fruits of enjoyment of life. But governments can be sued when they are conducting these sovereign functions, if these sovereign functions are not conducted in the legal manner. Okay, if these sovereign functions are not conducted in the legal manner, suppose police person arrest you. If the police person arrests you without the authority of law, then he is liable. He cannot then claim sovereign immunity. It's also called sovereign immunity. He cannot claim sovereign immunity, or the government has illegally trespassed on your residence. Government has illegally bulldozed your house. Okay, broken some portion of your house. Then Government cannot take the garb of sovereign functions. Sovereign functions can be claimed as an immunity by the government only when the government is acting legally. If the government is acting ultra vires, if the government is acting illegally, then government cannot claim sovereign immunity. Every illegal action of every person on this earth, even if the government, no exception, even if the government is acting illegally, government is equally liable to people of India. So when the government, though acting within its sovereign functions, but when these sovereign functions are carried out illegally, then the government is liable to compensate you. Government cannot claim immunity. Okay. Joint and independent tortfeasors. Okay, what is a joint and independent tortfeasor? When two or more persons whose negligence in a single accident or event causes damage to another person, they are called joint tortfeasors. In many cases, the joint tortfeasors are jointly and severally liable for the damages, meaning that any one of them can be responsible to pay the entire amount, no matter how unequal the negligence of each party was. Independent tortfeasors are those who act independently but cause the same damage. Okay, so joint and independent tortfeasors now we are discussing. When two or more person, okay, whose negligence in a single accident causes damage to another person. Suppose, okay, now two people, okay, A is driving a car and B is driving a bus. Suppose car is having four occupants in the car and B, the bus is having 40 passengers. Now both are driving on a two-way road, one two-way road, okay, one a road which is having two-way flow of the traffic, going and coming traffic on the single road. So both of them coming from the opposite directions. Okay, and both are driving negligently. One is under the intoxication, or one is having no license, or other is driving on a rash and high speed. Now they both enter into an accident. There is an accident because both are driving negligently. There is an accident. Okay, now what will happen? Who is liable here? Okay, in such a scenario, both people would be liable. Okay, in such a scenario, both people would be liable. Both A and B would be liable as joint tortfeasors because they both were negligent. Okay, they both were negligent in conducting themselves. So now out of this, what happens? Some people have become injured, or some have died, or some are died, some are injured. So now these families can definitely seek compensation from both of them. Okay, how can they seek compensation? They can seek compensation from both of them. How? Either jointly or independently. Okay, because they are both joint tortfeasors, so people can file a claim against both of them jointly or independently. It may be the case that people may file case against only the car driver and they do not file a case against the bus driver. It is their choice because the wrong has been committed by both. It is their choice to whom they want to file a case for whole of the amount or for the part of the amount. Suppose the court comes to a conclusion that suppose the court comes to conclusion that 80 lakh rupees is the compensation which has to be awarded to all the people who are injured or who have died, and whatever is the damage to the public property. And suppose some dhaba was also nearby, the restaurant has also suffered some damage, it has some shattered windows, some broken tables and so on all. Okay, so jointly the court says you people can claim 80 lakhs. So now they have an option. Either they can claim 40-40 from both of them. 40-40 split could be the, okay, sorry, I should rather say it a 50-50 split. Or they can take all 80 lakh from A or from B alone. They can take all 80 lakh from A or from B. Now you must be thinking that because the accident is caused by the joint act of both the parties, then why should A alone be liable and why should B alone be liable? Because they are joint tortfeasors, they should be jointly liable. Okay, it is very illegal to make any other person liable for the acts of his own as well as the others. Why is he liable for others? Okay, so in that case, what can be done? Suppose they have sought compensation from B and B is being made to pay all the compensation. Okay, now B has paid all 80 lakh. Now what this B can do? Okay, he has paid 80 lakh rupees, his whole house and everything has been sold out. Now what this B could do is, this B could file a case against A. Okay, against A, and he can tell the court that it was that we both were joint tortfeasors. Okay, some accident occurred and I as well as A were responsible for it, and 80 lakh was the compensation decided by the court, but all people asked the compensation from me. But because A was also an equal party of the compensation of the accident, now A should pay 40 lakh rupees. Okay, he should reimburse me for the 40 lakh rupees. Why? Because he is also a party to the accident. Now in this case, what court will do? Court will direct. Okay, court will direct the B. Sorry, court will direct the A upon the application of B, that because you were joint tortfeasors, and an accident is an accident which you both were party to the accident and you are joint tortfeasors. So you both should suffer the damages as well. Why B should alone suffer the damages? So court can ask A that you pay 40 lakh to B, or if the court feels that A is highly irresponsible, A was more responsible for the act rather than B, court may even ask him to pay 50 lakh, 60 lakh or 70 lakh or 30 lakh, whatever court comes to the conclusion. Court can ask direct the B to pay half or the proportion of the amount as per his act to the other party. This is how the law of tort in respect of joint tortfeasors work. We usually call them, not call them joint wrongdoer, but we call them tortfeasor. When someone commits a tort, we do not call him wrongdoer. The legal term is tortfeasor, and when we have more than one tortfeasor, we call them in the category of joint tortfeasor. Similarly, just like a joint tortfeasor, we have an independent tortfeasor. Suppose an independent person has filed committed a tort. Just like in this case, assume that there was no A, only B was the bus driver and he committed some accident due to his negligence. In that case, a simple case will be filed only purely against the B, and B alone shall be responsible because he has caused the act independently. There is no joint tortfeasor in this case, so B alone shall be liable. So, with this, in today's lecture, we have finished three topics: capacity to be sued, and we have done the essentials of the tort and the general defenses of the tort. I hope you all understood what we discussed today. Okay, and I have made my comments here for your easy understanding of the language used here. So we'll now close this lecture number 1 in the law of torts here only, and then in the next lecture we will proceed with our topic D. What is the topic D? Topic D is vicarious liability.